Good afternoon. This is Thomas Deal, Attorney Advisor at the DC Office of Human Rights. Very happy to participate in ERC's Fair Housing Beyond Borders webinar. My portion today will last about 10 minutes, and I'll be presenting on OHR Enforcement Guidance 20002, and we'll talk about the details of that guidance in just a moment. So the goals for this portion of the ERC webinar are to review the jurisdiction and mission of OHR, understand the scope of the DC Human Rights Act's fair housing provisions, become familiar with OHR Enforcement Guidance 20002. The full title of that is Fair Housing Laws and Affirmative Efforts to Reduce Homelessness in the District of Columbia. And lastly, learn how to file a legal claim related to fair housing in the District of Columbia. Pop quiz, just kidding, learning exercise. These are each true, false. So even though this is pre-recorded, I'll try to add a little bit of interactivity. So I'll give some time for you to write down your responses, and then we'll talk about the answers. So the first one, the DC HRA, DC Human Rights Act, fair housing provisions include all federal bases under the Fair Housing Act: race, color, sex, religion, national origin, familial status, and disability, as well as source of income, matriculation, status as a victim of an intrafamily offense, age, marital status, political affiliation, place of residence or business, family responsibilities, personal appearance, sexual orientation, and gender identity or expression. So that statement is either true or false. Number two, source of income under the DC Human Rights Act includes Section 8 housing choice vouchers. Again, true or false. Jot down what you think. Number three, homelessness is not a protected characteristic under the DC Human Rights Act. And number four, under the DC Human Rights Act, a fair housing complaint may be filed with OHR within 1 year of the incident, or in court within 2 years of the incident. Hopefully you've jotted down your responses, so let's take a peek at the answers. So the first one, all federal bases and all of those other ones additionally listed are protected characteristics in the fair housing section, and I've provided the code citation there for you. The second prompt is also true. Section 8 housing choice vouchers are included in source of income, also provided the code citation. True, homelessness is not a protected characteristic under the fair housing section of the Human Rights Act. And the last one is also true. Statute of limitations to file with OHR is 1 year, and for housing discrimination claims is 2 years in court. I've provided the code citation there for you as well. Let's talk about OHR's jurisdiction. OHR has jurisdiction over all allegations of fair housing violations occurring in the District of Columbia regarding private actors or the DC government, but OHR does not have jurisdiction over the federal government. And I provided the code citations there for each of those propositions. Please note, even though not a focus of this presentation, OHR and the Human Rights Act also cover employment, public accommodations, education, and governmental services. So it's quite broad. The mission of OHR is to eradicate discrimination in the District of Columbia, and that's per the statute. Scope of fair housing provisions under the Human Rights Act can be found at the code citations there. There are the 18 protected characteristics, which were listed on slide 3 at the beginning. And the types of topics included really is pretty much anything involved in housing. Failure to rent, failure to sell or bargain, all aspects of the housing transactions, redlining, block busting and steering, facilities repairs, statements, advertisements, access to multiple listing services for real estate agents, real estate associations, and the obligation to accommodate disability, religion, or victim of an intrafamily offense. Now let's talk about our primary topic, the enforcement guidance. So the background of this particular guidance is that OHR receives several inquiries regarding the potential implications under the Human Rights Act of governmental or non-governmental, nonprofit efforts to reduce homelessness in the District of Columbia. In response, we issued a guidance entitled Fair Housing Laws and Affirmative Efforts to Reduce Homelessness in the District of Columbia. The purpose of that guidance is to communicate OHR's position that such affirmative efforts by DC government agencies, nonprofits, and landlords to reduce homelessness, including providing assistance to individuals experiencing homelessness or low-income voucher holders, likely do not violate the Human Rights Act. Let's talk about the details a little bit. There were two key caveats or cautions that OHR provided in the guidance. Such efforts must be intended to address historical and present barriers to stable housing for individuals experiencing or who have experienced homelessness, including low-income voucher holders, and such efforts must not be intended to discriminate against or exclude others based on any characteristic prohibited by the Human Rights Act. So, little question and answer to get at some of the interesting aspects of this guidance. Number one, may DC government, nonprofits, or landlords engage in affirmative efforts to secure permanent housing for persons experiencing homelessness or low-income voucher holders without violating the Human Rights Act? Generally, yes, because of historical and present barriers to access to stable housing, including discrimination. However, the two caveats, such efforts are acceptable so long as both of these are true. The intention is to ameliorate objectively identifiable barriers to stable housing for persons experiencing homelessness or low-income individuals, and these efforts are not intended to discriminate against other potential tenants based on any protected characteristic under the Human Rights Act. A few additional thoughts. While homelessness is not an explicit protected characteristic under the Human Rights Act, the statute does prohibit place of residence discrimination. And similarly, while lack of income is not protected, the Human Rights Act's prohibition against source of income discrimination does encompass voucher holders. Lastly, it's OHR's position that efforts to reduce homelessness constitute legitimate, non-discriminatory public policy objectives. Again, so long as the entity is not motivated by invidious discrimination toward other potential tenants. So the key takeaway, ultimately, is that participating in governmental or non-governmental programs to reduce barriers to housing for persons experiencing homelessness and low-income individuals generally does not conflict with the DC Human Rights Act. Question 2, may a landlord waive credit requirements for persons experiencing homelessness or low-income voucher holders? And the key word in that question framing is may. Yes, so long as the intention of the waiver is to facilitate access to stable housing for persons experiencing homelessness or low-income individuals, and not to discriminate against other potential tenants based on any protected characteristic under the Human Rights Act. So it is permissive. Question 3, may a landlord coordinate with a government agency or a non-governmental agency to secure units to locate housing for persons experiencing homelessness or low-income voucher holders? Again, yes, but so long as the intention of the efforts is to facilitate access to stable housing for persons experiencing homelessness or low-income individuals, and not to discriminate against other potential tenants based on any protected characteristic under the DC Human Rights Act. Question 4, is a landlord required to waive credit requirements for voucher holders? Generally, no. Where a landlord requires a certain credit rating of all applicants, a landlord may require the same of voucher holders if the rules of the voucher program require the voucher holder to pay a portion of the rent. Put differently, in the case where a voucher program guarantees that the government will pay the entirety of the rent and customary fees for the duration of tenancy, at that point, there may be no legitimate reason to impose a credit requirement on that particular voucher holder. Thus, there's not a clear rule. We would have to look at each particular case, but the question is there a legitimate reason to check the credit of this particular applicant? The general rule is if that's a requirement of all applicants, then that's permissive. However, there may be a reason that accessing the credit of a particular voucher holder where they don't have any obligation, there may not be a legitimate reason to do that. A couple links here. The OHR guidance we were just previously discussing and other fair housing guidances can be found at this address here. The website's relatively easy to navigate, so if you go to ohr.dc.gov, you'll be able to access from there by clicking the drop downs. And a fair housing complaint may also be filed at ohr.dc.gov. The full address of that is there. Let's review what we covered today. The DC Human Rights Act is a broad remedial statute encompassing housing, employment, public accommodations, education, and governmental services. In the area of housing, there are 18 protected characteristics, and the statute covers all aspects of residential and commercial real estate. Participation in government or non-governmental programs to reduce homelessness likely does not conflict with the Human Rights Act, so long as the intention is to ameliorate objective barriers to housing and not to discriminate against others. Therefore, landlords may, but are not required to, waive credit requirements for voucher holders. And lastly, a complaint may be filed at ohr.dc.gov. Thank you for inviting me and the Office of Human Rights to participate today, and enjoy the rest of the seminar. Thank you.